They're all from the same date. They're all right, I see. So case number 3A 0257205, State versus Muhammad Idris. Charges vehicle operator refused to comply with the police officer. There are 2 infraction charges as well. 3A 0096934 is violation of a special trip permit, and 3A 0096933 failure to obey traffic control device and failure to renew his expired registration on a vehicle.
The hearing opens with multiple charges laid out clearly: refusal to comply, permit violations, traffic infractions, expired registration. The judge establishes the framework fast. This isn't chaos, it's structured. Every case number, every allegation placed on record. Before any philosophy enters the room, the court sets the tone. This is about specific conduct on specific dates. Precision matters here, and the court starts by anchoring everything in documented charges.
Mr. Kale, any contact from Mr. Idris?
Either Mr. Idris or a representative of Mr. Idris is present on Zoom, Your Honor. And I believe he may tend to proceed pro se, or at least without the assistance of public defense. So I would ask the court to inquire with him about that.
I will. So on the screen listed as Muhammad, authorized representative for Muhammad Idris. Is that right?
Defense counsel flags that someone appearing on Zoom may attempt to proceed without public defense. That's a critical moment. Courts must clarify representation immediately because it determines how the case moves forward. Self-representation is a right, but it triggers responsibilities. The judge wisely pauses to confirm who is actually speaking and in what legal capacity. Identity in court isn't symbolic, it's foundational.
First of all, I object to public defender saying that I'm pro se, which I am not. I'm the authorized representative on behalf of the estate, and I would like to request for continuance due to I made a request for discovery, and there was no email provided to me, and I was informed that only a phone number is available, and I called that phone number, and there was no answer, and I did not get any voicemail. And out of the 3 cases, I only received notice for 2. One is...
Here comes the pivot. Instead of confirming identity directly, the speaker reframes himself as an authorized representative of an estate. This is a classic sovereign-style positioning, separating the natural person from a legal entity. But criminal charges attach to individuals, not estates. The judge cuts straight to the point. Are you Muhammad Idris? Courts need a yes or no, not a philosophical detour.
Listen, I don't have the paperwork for that. Due for that reason, I would like to get a continuous.
All right, so let's start with this. Are you Muhammad Idris? Let's get the name straight to begin with.
That's the estate on the trust. I'm the authorized representative on behalf of the estate that the court is trying to administrate.
Well, the state's not charging the estate. The state is charging Muhammad Idris. So that's who we need to address. Is that you, is my question.
I object. If I have a question for, that's a question for the prosecutor, correct?
Well, you're here asking for a continuance because you want something else.
The exchange tightens. The judge insists the estate is not charged. The named individual is. The defendant attempts to shift the burden back toward the prosecutor. But procedurally, before granting a continuance, the court must know who is requesting it. Authority to speak isn't assumed. It must be legally grounded. The judge remains patient but focused. Establish identity first, arguments second.
I have to know who it is that is requesting the continuance and how you speak on behalf of Muhammad Idris.
I'm the authorized representative of the estate like my family name is Idris, given name Muhammad Ismail, for the estate, which is Muhammad Ismail Idris estate on a trust.
All right. As I say, the estate is not being charged with the criminal offense. Muhammad Ismail Idris is being charged with criminal offenses. Now, you indicate that you only got 2 of the 3 notices. Which charges did you get notice of? Did you get notice for the failure to obey traffic signal?
When asked which notices were received, the response loops back into estate language. This is where momentum starts slipping. Courts operate on statutory structure, not trust theories. The judge calmly explains, the estate wasn't driving the vehicle. That line slices through the abstraction. Criminal liability attaches to conduct by a person, not to conceptual frameworks.
I object to you're saying this has nothing to do with the estate. It has everything to do with the estate and the trust that's being charged.
Well, not to be argumentative, Mr. Idris, but the estate wasn't driving the vehicle. I suspect the city or the state will try to prove that Muhammad Idris was driving the vehicle. That's their job in this case.
I object. That's a hearsay. The court is assuming and presuming that's the case, which is not. So if you can continue with the continuous, I'll appreciate it.
Well, I'm going to ask the city, or the state rather, to establish probable cause at this time on the charge ending in, or the case number ending in 7205.
Objections escalate. Hearsay, presumption, assumption. But courtroom objections must target admissibility of evidence, not general disagreement. The judge moves forward by requesting probable cause from the state. This is strategic. Rather than debate identity endlessly, the court shifts to whether there's enough factual basis to proceed. It's a procedural reset.
Which is the vehicle operator refusing to comply with the officer. You've already been sworn, Ms. Mann, so we'll go ahead.
The charge of refusal to give information on May 11th, 2023, Officer Kelsler responded to a request for assistance from Officer Turner, who had performed a traffic stop on a commercial motor vehicle that was traveling in a left lane prohibited for CMB southbound I-5 at milepost 96. The driver was later ID'd by his DOL photo on file as Mohammed Ismail Idris, and
I object.
Both officers within the ID despite multiple...
Mr. Idris, hold on, Ms. Mann. Mr. Idris, please, let her finish.
Okay.
Let her finish. Go ahead, Ms. Mann.
Refused to provide both officers with an ID despite multiple requests by both officers. He was cited for operating a vehicle and refusing to comply with a police officer and released.
He was also charged with the infractions at that
The
time.
prosecutor outlines the traffic stop, refusal to identify, and citations issued. Clear narrative, specific date, specific conduct. The attempt to interrupt mid-recitation doesn't land. Judges expect probable cause summaries at arraignment. It's routine. Once the summary is complete, the legal threshold for moving forward is largely met.
Yes, Your Honor, and I have a probable cause for the special fuel trip permits violation as well, if you'd like.
Yes, why don't you give us that too?
On May 16th, 2023, Officer Turner observed a tractor-trailer traveling south on I-5 near milepost 98, speeding and traveling in a restricted left lane. The officer made contact with the driver, who refused to identify himself, but was identified through his DOL photo on file as Mohammed Ismail Idris. While looking up his inspection history, it was revealed that the registration on the power unit had expired several months earlier and was revoked by the Washington State Department of Licensing. He was cited and released.
Is it my turn to speak?
All right, Mr. Idris, it's now your turn. Go ahead.
I object.
Additional probable cause follows. Restricted lane, expired registration, refusal to identify. The pattern matters. Multiple stops, similar behavior. When the defendant finally speaks, he circles back to continuance and lack of discovery. That's a legitimate procedural concern, but it loses force when wrapped in jurisdictional arguments about estates and consent.
I requested for continuance, and I was not informed if it was denied or granted, and I do not consent to being for the court to move forward. If you guys decide to move forward, I prefer physically present instead of a Zoom call, if you guys decide to continue.
And what's the basis of your objection again? Why you want a continuance?
The reason I need the continuance is out of the 3 cases, the case number, I only got 2 notices, not the 3rd one. One is missing. And also I requested for discovery to the clerk of the court, and they said I have to get hold of the prosecutor office, and I got hold of the prosecutor office. There's no email for me to request for the discovery. The only way is a phone number. When I called the phone number, nobody answered.
The judge probes the basis for continuance. Missing notice and lack of discovery access are valid issues if substantiated. The court even explores whether infractions were combined on one document. Notice how the judge offers practical explanations rather than dismissing concerns outright. This is measured judicial management, not confrontation.
So how can you guys continue without, I don't even have any discovery, so I don't know what's up against me. I don't have the details of the discovery.
Well, you've heard what's against you. Ms. Mann just repeated what she believes the state will be able to prove in this case.
There's not a proper notice.
Mr. Idris, hold on. It may be that the 2 infraction numbers appeared on the same document, case ending in 933 and case ending in 934, since they're both infractions. And then the second one would end in 205, which is a criminal charge. So that's a possibility. But based on your request to have this set over, we will set out the arraignment.
The court grants a reset, arraignment postponed, in-person appearance allowed. That's accommodation. Importantly, the judge refrains from formally finding probable cause immediately, giving room for document review. This demonstrates restraint. The system bends to ensure fairness, but it doesn't concede jurisdiction.
And you may appear in person. There's nothing stopping you from appearing in person.
Physically present.
Yes, in person. All right, although I believe there is probable cause been established, I'm not going to find that today to give Mr. Idris the opportunity to look at all these documents. And Ms. Mann, is there some better way for him to request the discovery in this case that he's talking about?
Not that I know of, Your Honor. I could check with my supervisor.
All right, go ahead. In the meantime, while we're looking for that information, Mr. Idris, I want to confirm a mailing address for you or for your estate. Let me check for a moment.
I object. I'm not a Mr.
Pardon me?
I say I object. I want to make a correction. You called me Mr. I'm not a Mr. Mr. is a title.
Is your address?
Now comes the addressed issue. Mailing information becomes contentious. Refusing standard address formatting complicates due process. Courts must be able to send notice reliably. Without it, warrants follow. The insistence on titles and private locations doesn't override procedural necessity. Service of notice isn't ceremonial, it's constitutional.
A private location I can only receive for mail-in purposes only, for notices.
Is that a P.O. box in Tukwila?
That ends with...
I'm seeing a P.O. box stated Tukwila, Washington.
There's a dash at the end, 9998. There's 999 and 8. Those 4 digits is very important to put it on there.
So 8-888-9?
No.
I messed those last 4 up. What? What's next?
Like I said, I don't have an address. I have a private location where I can receive for mail-in purposes only. And the only thing I will indicate is the last 4 digit after the end of the location, where it ends 9998.
Is that a street address or a mailbox? Post office box.
That's my mail-in location where I can receive notices only.
We can't address notice to you at 9998. I need more than that. What happens, Mr. Idris, is if you don't respond to this, there's going to be a warrant issued for your arrest. We have to give you notice first.
The prosecutor enters, noting citations were handed directly at the scene. That undercuts the notice argument significantly. Returned mail is mentioned, hinting at a pattern. Then comes the sharper move, questioning whether the defendant has legally appeared at all. If he hasn't, a warrant becomes possible. That's leverage grounded in procedure.
Mailing address here. Mr. Idris, we have 2 addresses from the Department of Licensing. One is on Avenue in Seattle, and the other is a P.O. box in Tukwila. If you're not willing to provide us with your email address, we're going to just send notice to those 2 addresses.
I object. Again, I'm going to make a correction. I'm not a Mr., which is a title. If you can call me with my proper name, which is a family name and a given name, I'll appreciate that.
Yes, Muhammad Idris. We're going to send notice to those 2 addresses that we have.
You meant to say
Unless you give us
my
something different.
You meant to say my family name, which is Idris.
All right, we're going to use that. That's what he sent to us, requesting information about court, correct? All right, looks like we do have an email address for you when you
Your Honor,
requested
Just before we
information.
go on.
All right, Mr. Farrow, let's hear from you.
Thank you, Your Honor. I was listening on the YouTube. I wanted to address the court just to highlight the fact that Mr. Idris was given the constitutionally required notice at the scene on at least 2 of these cause numbers. There are citations in the record. Those were handed to him, and he was advised of the upcoming court date. That's kind of my first point. So I think if the court wants to continue, I don't know when he was first scheduled for arraignment, but it looks like this has been going on for a little bit. If the court wants to continue on those 2 matters, I'm happy to. I mean, it says here, it's checked the box for the ticket was served on the violator. I'm happy. I guess I could send something to one of these email addresses, but I would also urge the court to note that if you look on Jabs, we've tried sending mail to Mr. Idris. It is not, or it's been returned. Finally, Your Honor, and I'm not trying to be silly about this, but I've sort of heard these arguments before in court, and I think I know where we're going with this. The state's not satisfied legally that the defendant in this case has appeared today. I think he's claiming to be some sort of representative for some sort of estate or trust or other nonsense. But based on Mr. Idris's failure to appear today, the state would request the court to issue a warrant in the amount of $10,000. Thank you, Your Honor.
The state argues the appearance is insufficient and requests a warrant. The defendant counters with broad objections: hearsay, tacit agreement, affidavit demands. But arraignment isn't trial. The court doesn't need sworn testimony from the prosecutor at this stage. The judge balances carefully, acknowledging the issue without escalating to a warrant immediately.